Act, and therefore cannot be regarded as proper pre-action notice. Counsel recommended the decision of the Court of Appeal in Gbadamosi against NRC 2006 to me to follow. In response, it was submitted by the learned counsel for the claimant in the claimant's final written address that the position of sole administrator or managing director to whom the letters in Exhibits E and F were addressed were at the time of the letters equivalent to the position of chairman, and they are within the same cadre as principal officer. It was also submitted that service of process on a registered company is sufficient when left at the registered office, and in this case, the pre-action notices were served in the defendant's registered office. Counsel relied on the case of Ben Thomas Hotels against Sebi Furniture 1989 and Abic Nigeria Limited against EcoBank Nigeria PLC 2010. In paragraph 24 of the statement of facts, the claimant pleaded that a protest letter and intention written by his solicitors on 1st June 2017 was served on the defendant. In paragraph 17 of the statement of defense, the defendant admitted receiving the said letter, but contends that there is no adequate and proper notice of intention to sue in the letter. The letter is Exhibit E, and from the facts of the parties, it was served on the defendant before the claimant instituted this suit on 23rd June 2020. The provisions of Section 83(2) of the NRC Act is clear to the effect that no suit shall be commenced against the corporation until 3 months after a corporation intending plaintiff or for the agent or his agent, and such notice shall clearly state the course of action, the particulars of claim, the name and abode of the intending plaintiff, and the reliefs which he claims. The Exhibit E was served on the defendant and received by the defendant 3 years before the institution of this suit. This suit was instituted more than 3 months after the service of the letter on the defendant. Exhibit E was addressed to the managing director of the defendants. Exhibits J and O written by the defendant was signed for the managing director. It is therefore obvious that there is the office of managing director in the defendant. Thus, Exhibit E was addressed to an officer of the defendant. The fact that it was not addressed to or served on the secretary or the chairman does not render the letter incompetent. It was a letter meant for the defendant and it was received by the defendant. The person who received it or the person it was addressed to is irrelevant. The important thing is that the defendant to whom it was meant had knowledge of the letter. I have also gone through the content of Exhibit E. It contains the claimant's complaints against the defendant, the demands of the claimant, and it gave a 30-day notice of intention to sue the defendant. In addition to damages that will be claimed against the defendant, the letter substantially complied with the provisions of Section 83, subsection 2 of the NRC Act. By the letter, the defendant had notice that the claimant intends to sue it. It is also informed of the issues of cause of action and the demands or claims of the claimant. The intention of the lawmakers for making provisions in statutes for service of pre-action notice is to give notice of intention to sue to statutory bodies or their officers and give time to attend to the demands before filing suit against such statutory bodies or their offices. It is a mere technicality to insist, as done by the defendants, that letter in Exhibit E is not sufficient pre-action notice. I am of the view that Exhibit E constitutes proper and sufficient pre-action notice required to be served on the defendant in Section 83(2) of the NRC Act. Now to the decision on the main suit. I will now examine the case of the claimant, and the issue which I shall be considering is whether the claimant has proved the claims he sought in the suit. In Relief 1, the claimant sought a declaration that his employment with the defendant is still subsisting up till the time of his retirement. And in Relief 2, the claimant sought payment of his accumulated salaries and leave grants from March 1999 to the time of his supposed retirement from service of the defendant in July 2017. From these claims, the claimant has clearly agreed and acknowledged that he was retired from the service of the defendant. But what I find not in place is his reference to July 2017 in his claims, supposedly to be the date of his retirement. The retirement of the claimant from his evidence is by the letter dated 16th August 2016, where the defendant commuted his dismissal to retirement. The letter is Exhibit O, and the content of the letter reveals that the retirement is with effect from from 30th April 1999, effective July 2017. Even in his evidence, the claimant did not say his retirement was on July 2017. What he pleaded in paragraph 22 of the statement of facts and mentioned in his evidence is that he approached the accounts department of the defendant to calculate his salaries from the date of his purported dismissal till July 2017. Thus, July 2017 was not the date of his retirement from service, but the date up to which his claims, salaries, and increments were calculated. The claimant's case, as per the claim in Relief 1, is his contention that he was still in the defendant's employment up to the date he was retired from service. In his evidence, the claimant stated that by a letter dated 28 April 1999, he was dismissed from the employment of the defendant. The letter is Exhibit D. The claimant said he protested the dismissal through a letter written by his lawyers. And he also wrote to plead that his dismissal be converted to retirement so that his 17 years of service in the defendant will not go down the drain. Then the defendant wrote Exhibit O on 16th August 2016 to inform him that his dismissal had been converted to retirement. The defendant also wrote to him on 24th January 2020 to inform him that the defendant still stands by his decision to convert the dismissal to retirement. This letter is Exhibit J. In the statement of defense as well as in the evidence of DW1, the defendant confirmed the dismissal of the claimant and stated that the dismissal was properly done. The defendant also confirmed that it wrote the letter of 24 January 2020, Exhibit J, and said the letter only affirmed what the claimant had been told since 28 April 1999. Let me add that there is nowhere in the statement of defense and the evidence of DW1 where the defendant denied that the dismissal of the claimant was commuted to retirement. It was also not denied that the defendant wrote Exhibit O to the claimant. From the evidence of the claimant, it is clear that he was first dismissed from service by Exhibit D, dated 28 April 1999. The dismissal was with effect from 30th April. Upon the claimant's plea for conversion of dismissal to retirement, the defendant wrote the letter in Exhibit O, dated 16th August 2016, commuting the claimant's dismissal to retirement. The letter clearly stated that the retirement was with effect from 30th April 1999. From the content of Exhibit O, the claimant's retirement from service was with effect from 30th April 1999. This is the same date the claimant was dismissed from service. The implication is that his dismissal was merely converted to retirement without any change in the effective date. Thus, the effective date of his retirement is 30th April 1999. When the claimant sought that it be declared, he said that he is still in employment of the defendant up to the date he was retired from service. I do not think that that raises any issue. The date of his dismissal is the same date of his retirement. Before the dismissal, it is not in dispute that the claimant was an employee of the defendant. Of course, that was why he could and was dismissed from the employment. Thus, it is not an issue that the claimant was an employee of the defendant up to 30th April 1999, being the date of his dismissal and subsequent retirement from service. From the evidence of the claimant, he is aware that he was dismissed from the employment of the defendant on 30th April 1999, and he never worked for or engaged, nor was engaged by the defendant thereafter. It was the dismissal that was converted to retirement. Accordingly, between the date of the dismissal letter and the date of the letter commuting the dismissal to retirement, the claimant was not in the employment of the defendant. That is to say, the claimant's dismissal subsisted until the defendant wrote Exhibit O on 16th August 2016, converting it to retirement. Therefore, taking both the dismissal and retirement into account, the claimant's employment was terminated by the defendant on 30th April 1999. The claimant does not have any quarrel with the retirement. That is why in Relief 1, he simply sought a pronouncement that his employment subsisted up to the time of his retirement. He appears to be comfortable with the retirement. The only complaint he has made with respect to the retirement is non-payment of his pension and gratuity. Therefore, whether the retirement is proper or not is not an issue. I see, however, that the claimant is challenging his dismissal from the service of the defendant. I've carefully read the pleadings of the claimant and the evidence adduced by him. The complaints he has made touching on his dismissal by the defendant are as follows. The dismissal was without any justification or just cause. His dismissal was done in error. The defendant refused to implement the recommendation of a review panel and the resolution of a meeting presided over by one Mrs. M.A. Nnodi, both of which recommended that he be recalled. His dismissal from service was not in accordance with the disciplinary procedure of the defendant of 1984, and his dismissal is void for irregularities and inconsistencies with the said disciplinary procedure of 1984. In view of these allegations of the claimant, his case appears to be that the dismissal was wrongful in the first place. It is therefore necessary to consider whether the claimant proved that his dismissal in April 1999 was wrongful. One of the complaints of the claimant against his dismissal is that his dismissal from service was not in accordance with the disciplinary procedure of the defendant of 1984, and his dismissal is void for irregularities and inconsistencies with the said disciplinary procedure of 1984. The claimant tendered the disciplinary procedure in evidence. It is Exhibit G. On the other hand, the defendant asserted that the claimant's dismissal was in line with the disciplinary procedure of the defendant. This affirmation of the defendant put the burden of proof on the claimant to prove the disciplinary procedure and how his dismissal was done in violation of the disciplinary procedure. It is also the duty of the claimant to prove the alleged irregularities and inconsistencies with the disciplinary procedure in his dismissal. The claimant merely said his dismissal from service was not in accordance with the disciplinary procedure, but he did not plead or explain in his evidence what the disciplinary procedure is that was not followed by the defendant when he was dismissed. He also alleged that there were irregularities and inconsistencies with the disciplinary procedure, but he did not mention or give the particulars of the irregularities and inconsistencies with the disciplinary procedure. The claimant simply tendered Exhibit G in evidence without any evidence or explanation as to how the document relates to his allegations. The law is settled that a document tendered in evidence, whether by a witness or from the bar, the person who is relying on the document must link it to the aspect of his case it relates to. There must be oral evidence adduced to explain the areas where the document relates to the party's case and why the document was tendered in evidence. Where this was not done, it means that the document was merely dumped on the court and it has a fatal consequence to the case. It is not the duty of the court to which the document was dumped to spend precious judicial time investigating the documents or in order to help the party link same to the specific areas of the party's case. See Maku against Al-Makura, 2016. It is also trite that a claimant who alleges wrongful dismissal must plead and prove the terms and conditions of his employment, the circumstances under which his employment can be terminated or dismissed under the condition of service, the procedures stipulated in the condition of service for termination of the employment or dismissal, and the manner in which the termination or dismissal breached the said terms and conditions of the employment. See Petroleum Training Institute against Matthew, 2012. WAEC against Oshonebo, 2007. In this case, although the claimant alleged wrongful dismissal by failure to follow the disciplinary procedure of the defendant, he failed to plead and prove the disciplinary procedure, which the defendant allegedly did not comply with. The claimant also alleged that the defendant refused to implement the recommendation of a review panel and the resolution of a meeting presided over by one Mrs. M.A. Nnodi, both of which recommended that he be recalled. The claimant tendered the report of the review panel and the resolution of Mrs. M.A. Nnodi meeting in evidence. They are exhibits K and L respectively. The defense of the defendant is that although the claimant was recommended for reinstatement, the defendant did not reinstate the claimant. The defendant also averred that the case of the claimant did not fall among the cases recommended for recall in the report of the review panel, and the defendant has the discretion to implement the recommendation of Mrs. M.A. Nnodi. I have carefully examined exhibits K and L, and it is observed that the documents or the said recommendation of a review panel and the resolution of Mrs. M.A. Nnodi meeting were made after the claimant had been dismissed from the employment. Thus, the fact that the defendant refused to implement the recommendation or the resolution is not a factor to be considered in determining the wrongfulness or otherwise of the dismissal of the claimant. In addition, the defendant is not under any duty to implement the recommendation or the resolution of a panel and committee it set up. The decision of the defendant not to implement the recommendation of a review panel and the resolution of Mrs. M.A. Nnodi meeting does not render the claimant's dismissal wrongful. The claimant also alleged that the dismissal was without any justification or just cause. It is his evidence that before the letter of dismissal in 1997, he was alleged to have conspired in stealing and receiving stolen property. He was suspended from duty, prosecuted for the offenses in a law court, but for lack of evidence, he was discharged by the Magistrate Court of Kaduna State, sitting in Kafanchan on 5th March 1998. The ruling of the court is Exhibit C. Upon the ruling of the court discharging him, he was reinstated to duty on 3rd July 1998, and all his salaries, which were withheld during his suspension, were paid to him. He was also promoted to Senior Technical Officer, Tract, via the letter dated 2nd September 1998, and further promoted to Principal Technical Officer 2, Track, via a letter dated 7th October 1998. Then, by a letter dated 28th April 1999, he was dismissed from the employment. The summary of the above evidence of the claimant is that he was suspended from duty as a result of criminal allegations against him, for which he was prosecuted in the Magistrate Court Kafanchan. As a result of the suspension, he was not paid any salary. But when he was discharged by the court on 5th March 1998, the defendant recalled him on 3rd July and paid all his outstanding salaries during the period of suspension and promoted him twice. The claimant also said that prior to his dismissal on 28th April 1999, he was not served any query, nor had he any disciplinary issue. It was for these reasons, he said, there was no justification for his dismissal. The defendant, on the other hand, averred that the dismissal of the claimant was done with justification. Although the defendant confirmed that the claimant's salaries, which was withheld during the period of his suspension, were paid, it was averred that the claimant was never acquitted of the offense against him, as he was only discharged. It was further averred that the claimant was promoted erroneously. During the period, the claimant was not reinstated into the employment of the defendant because no letter of reinstatement was issued to him. The officer in charge of promotion of staff erroneously promoted the claimant based on the directive of the Director of Civil, who had names of members of staff in bulk promotion exercise and was not aware that the claimant had not been reinstated. Now that the claimant said his dismissal is without justification, the burden shifts to the defendant to prove that the dismissal was justified. The claimant proved that after his discharge by the court, he was promoted twice by the defendant before he was dismissed on 28 April 1999. The promotion letters are exhibits B1 and B2, dated 2nd September 1998 and 7th October 1998. The defendant admitted that the claimant was promoted, but contended that the promotion was done in error. The reason the defendant alleged error in the promotion of the claimant is that after the discharge of the claimant by the court, the claimant was not reinstated into the employment because no letter of reinstatement was issued to him. And the officers who issued the promotion were not aware that the claimant had not been reinstated. It is not in dispute that after the claimant was discharged by the court, the defendant paid to him all the salaries accruing to him during his period of suspension. By subsequently paying to the claimant salaries he was not paid during suspension implies that the claimant's suspension had been vacated. Again, the fact that the claimant's employment was not terminated at the time of payment of his accrued salaries, the implication is that he was recalled. There need not be a formal letter of recall. The acts of the defendant clearly reveals intention to have the claimant back to the employment. Without a doubt, I find that the claimant was recalled to duty from suspension after his discharge by the court. There is no evidence from the defendant that the claimant's employment was terminated at any time before his discharge by the court and before the promotions. So it is not on record of the defendant that the claimant is.
Is he using his own? As it
no longer his employee, as the claimant's promotions cannot be in error as claimed by the defendant. The promotion of the claimant was done by the defendant. The defendant could not have promoted the claimant if he was not recalled from suspension. With all intent and purposes, the defendant knew the claimant was still its employee at the time of the promotions and duly promoted the claimant. In my view, the defendant was unable to prove that the claimant was promoted. Accordingly, the claimant's promotion was duly done by the defendant after the claimant's discharge by the court. From the evidence, I find that the claimant was recalled from suspension, paid his outstanding salaries, and promoted twice in the employment before he was dismissed. Now, having done all this, it means the criminal allegations for which the claimant was prosecuted and discharged had been overtaken and laid to rest. The claimant also said that prior to his dismissal on 28 April 1999, he was not served any query or had any disciplinary issue. Therefore, what was the reason the claimant was later in April 1999, 9 months after recall from suspension, dismissed from the employment? The defendant is unable to adduce any reason for the subsequent dismissal of the claimant, other than to say the claimant was never acquitted of the offense against him. Since the defendant knew the claimant was not acquitted, why did it not terminate his employment immediately upon his discharge by the court? Why recall the claimant for suspension, pay his salaries, allow him to continue to work, and even promote him? After the claimant was recalled from suspension, paid his salaries, and promoted, there was no misconduct shown to have been committed by him between the time of his discharge and the time of his dismissal to warrant his dismissal. Obviously, the defendant has failed to give any good cause to justify the dismissal of the claimant. I have also examined the dismissal letter Exhibit D to see the reason given for the dismissal of the claimant. The claimant was informed that the head of state, General Abdusalam Alhaji Abubakar, by virtue of powers conferred on him under the Public Officers Special Provisions Decree number 17 of 1984, dismissed the claimant from the service of the defendant with effect from 30th April 1999 in the public interest. By the content of the letter, the dismissal of the claimant was done by the head of state and not by the defendant. The head of state acted pursuant to provisions of the Public Officers Special Provisions Decree 17 of 1984, and the reason for the dismissal was in the public interest, quote and unquote. Section 1 of the decree mentioned the grounds under which the head of state may remove, dismiss, retire a public officer from service. Public interest falls under Section 1, subsection 1D, and it provides as follows. The general conduct of the person concerned in relation to the performance of his duties has been such that his further or continued service will not be in the public interest, quote and unquote. It is clear from the above provision of the decree that public interest is not a reason to dismiss an officer under the decree. The reason to dismiss under the provision is the conduct of the officer in the performance of his duty, which is found not in public interest to continue in the employment. Therefore, public interest is not in itself a reason in the decree to dismiss an officer. The dismissal letter did not mention any conduct of the claimant, which renders his continued employment not to be in the public interest. In the view of that omission, it is unlawful to dismiss the claimant simply for public interest. Therefore, public interest is not a justifiable ground or reason to dismiss the claimant. From the foregoing, I find that there was no just cause or any justifiable reason for the claimant's dismissal via the letter dated 28 April 1999. For all the reasons above, I hold that the claimant's dismissal was wrongful. Having come to the conclusion that the claimant's dismissal was wrongful for not being justified, what is the effect to the claimant's case? When the claimant sought that his employment be considered still subsisting, the implication may result to setting aside the dismissal and treat the employment as having not been terminated or dismissed. This type of remedy is applicable only to employment protected by statute. See Esevore against NEPA 2002. The claimant has not shown that his employment is protected by statute. He did not even plead the condition of service which regulated his employment with the defendant. Although he referred to his employment letter, which he tendered in evidence, it is Exhibit A. In paragraph 8 of Exhibit A, the claimant's condition of service is as contained in the document and in the regulation made by the defendant. The claimant, other than the disciplinary procedure Exhibit G, did not tender any regulation made by the defendant in evidence. Although the defendant is a statutory body, not employment of all statutory bodies has statutory flavor. The terms and conditions of the employment in such statutory body must be statutorily provided to make the employment a statutory employment. See Imolame against WAEC 1992. Also in Olusheye against Lawman 2013, it was held thus, quote, an employment with statutory flavor arises when the body employing the man is under some statutory or otherwise restriction as to the kind of contract which it makes with his servants on the grounds on which it can dismiss them. Generally, where an employment or a contract of service is governed by the provisions of statute, or where the conditions are incorporated into regulations which derive their force from a statute, an employee who is a party to the contract of service is said to enjoy a legal status higher than the ordinary one of master and servant, unquote. See also CBN against Iguilo, 2007, Pakuade against OAUTH, 1993, Ide against University of Ilorin, 1994. In the absence of proof by the claimant that the terms and conditions of his employment are statutory, it leaves the conclusion that his employment with the defendant was that of master and servant. In master and servant employment, a termination of the employment, whether wrongful or otherwise, put the employment to an end. Where a master has been terminated, his servant's employment, even though wrongfully, the employment stands terminated. The employment cannot be declared to still subsist, nor can the termination be set aside. See Ikale against FAN, 2003, Esevore against NEPA, 2002, Uzondu against UBN PLC, 2008. Therefore, even though the dismissal of the claimant is found to have been wrongfully done, it cannot be reversed, save to entitle the claimant to damages only for the wrongful dismissal. From the foregoing, although the dismissal of the claimant was wrongful for the singular reason that it was not justified, the dismissal, however, effectively put employment, sorry for that interruption. The employment of the claimant with the defendant was brought to an end on 30th April 1999. The claimant's employment did not subsist beyond 30th April 1999 when he was dismissed or when the defendant decided to commute the dismissal to retirement. The result is that the claimant is not entitled to the declaration he sought in Relief 1 as it was not established. This conclusion affects the claim sought by the claimant in Relief 2. He had sought orders directing the defendant to pay him accumulated salary to July 20 and leave grant from May 1999 up to July 2017, which is the date the claimant based his claim for payment of salaries and leave grants. The payments sought by the claimant are for periods he was no longer in the employment of the defendant, having been dismissed or retired. See Oboth against CBN, 1993. Also, Springbank against Babatunde, 2012. The claimant is consequently not entitled to the claims in relief 2. The claimant also claims the sum of 20 million naira as general and exemplary damages against the defendant. I have held that the dismissal of the claimant was wrongful. The claimant was dismissed from the employment without any just cause. He is therefore entitled to damages for the wrongful dismissal. The claimant also sought an order for payment of his gratuity, pension, and all his emoluments for the years he put in service of the defendant. He stated in his evidence that when his dismissal has been converted to retirement, it was without any benefit in form of pension or gratuity up till this moment. I've mentioned earlier in this judgment that the defendant did not deny issuing Exhibit O to the claimant. The defendant also did not join issues with the claimant on non-payment of pension and gratuity to the claimant upon his retirement from service, vide Exhibit O. The claim of the claimant, which the defendant contested, is the claim for salary, promotion, leave grant, and increment. In the letter of retirement, Exhibit O, it was stated by the defendant that the claimant's dismissal was committed to retirement with effect from 30th April 1999, but his pension will commence from 1st August 2016. The letter further stated that since the claimant had served for more than 10 years, he is entitled to payment of pension and gratuity. The effect of Exhibit O is that the defendant acknowledged that the claimant's retirement from service was on 30th April 1999, and he was entitled to be paid pension and gratuity computed at the rate of his grade level at the date of retirement. The defendant is bound to comply with terms of the letter. Having converted the claimant's dismissal to retirement, the defendant is bound to pay the claimant the benefits accruing to him on the basis of retirement. The claimant said he has not been paid his pension and gratuity till date. The defendant did not deny this fact. I hold that the claimant succeeds in relief 3. To conclude this judgment, I find and hold that the claimant failed to prove reliefs 1 and 2. These claims are dismissed. Reliefs 3, 4, and 5 succeed, and they are granted in the following terms. An order is made directing the defendant to compute and pay to the claimant his gratuity and pension for the years put in service of the defendant up to April 1999. 2, the sum of 5 million naira is awarded to the claimant as general damages against the defendant. 3, 10% interest on the judgment sums from the date of judgment to the date of compliance by the defendant with the orders of the court. 4, 200,000 naira as cost of litigation. Judgment is entered accordingly.
As court places.
Thank you very much.
We are sincerely grateful, my Lord, for well-considered judgments. We are most obliged, my Lord. We shall be craving the indulgence of your Lordship for the hard copy of the judgment or either soft copy at a convenient time.
You'll get the hard copy. I'm sure that the registrar will come to my location to obtain the copies, the signed copies later today. So between probably today and tomorrow, you should be able to get
we are sincerely grateful, my Lord.
Thank you very much.
We are grateful. Thank you, my Lord.
Thank you.
Thank you, my Lord. Thank you, my Lord. I sincerely appreciate for the judgment, and I pray God will continue to uplift you and give you the wisdom to carry on your duty. Thank you so much.
Thank you.
Thank you, my Lord.
I'm grateful, my Lord.
I'm grateful, ma'am.
Thank you. Thank you very much. All right. I'll just take like a minute to drink some water, and then we'll call the next case.
Okay, my lord.
As God places.
Okay.
Just want to drink water like 3 minutes. Congratulations.
Very great.
Congratulations.
Thank you.
Congratulations. Wá wẹ̀ nsìn, wá wẹ̀ nsìn.
Máa wẹ̀ fún yín. Ẹ jẹ́ kí n padà wá kí n wá wẹ̀ fún yín. Ìgbà ó ní màá wá gba
Ọ̀la
statement.
náà, ọ̀la.
Yes.
Ẹni tí ìjọba lọ sí. Ṣèlú mi nàlẹ́ wọ̀. Ẹ lọ ẹ máa kọ application.
Ó ti pẹ́ tí mo ti fẹ́ rí iṣẹ́ wọn pé mo wá ń gbà tọ́jú mi.
Ẹgbẹ́ náà fún wa.
Thank you.
Kí máa dẹ̀ tán? Okay.
Okay.
Anche reale che naka.
Okay. I'm back.
Yes, ma'am.
Are we set for the next matter?
Yes, my lord.
Are the parties present?
Yes.
Are they represented?
The claimant counsel left for his chamber, but the defendant counsel is here.
Does he have the Zoom link?
Yes, my lord.
So perhaps you should call him and tell him that we're starting to read this. We want to take the second matter now.
Okay, my lord.
You want me to give you a minute?
Yes, ma'am.
Okay, I'll give you a minute.
Okay.
But what's his name? Is it the one?
No, register. No, like, try to get something.
Yes.
Then not the person. Hassan Galaxy. Ibrahim Abdullahi. This is the code. This is the guy that told us.
Yeah, join us. But I call it.
Like he's done with the other one. He's done with the other one. No, I mean the other one.
Who is this Hassan? Hassan Galaxy. Hassan.
Okay, are we good to go now?
Yes, madam.
Okay, the parties are present.
Yes, madam.
Appearances, please.
May my Lord be pleased.
Yes.
M.I. David.
Yes. Yes.
With me is
Barrister Ibrahim Abdullahi.
Ibrahim Abdullahi. IBM.
Yes.
And J.O. Okete.
Yes.
Yes, my Lord.
And your appearances.
For the claimant.
Yes.
May it please your lordship.
Yes.
Edwin.
Yes.
My lord, I most respectfully appear for the defendant in this matter. Thank you, my lord.
Thank you. Okay. I'm going to read the judgment from this screen directly, and I'll proceed to read from my directly to, I will proceed to my decision straight away. The pleadings and the evidence of the parties show that these facts are not in dispute. The claimant was employed by the defendant on 15th March 2002. The claimant was posted to the Court of Appeal, where he initially worked in the headquarters of Court of Appeal before he was transferred to Lagos Division of the Court of Appeal in April 2009. While in Lagos Division, the claimant was given a query dated 12 January 2010, which he answered. He was thereafter given a warning letter dated 8 February 2010. In September 2011, the claimant was transferred from Lagos Division to Makurdi Division. On 10 July 2018, he received a letter dated 22nd June 2016 from the defendant dismissing him from service on the ground that the claimant was absent from duty without permission or leave. The dismissal of the claimant from service by the defendant is the claimant's course of action in this. From the totality of the evidence of the claimant, he has challenged his dismissal on two grounds, which are that he was not absent from duty as alleged, and that he was never given any invitation or opportunity by anybody to defend himself before his dismissal from service. It is on the basis of these grounds the claimant sought the reliefs contained on the complaint. In view of the case as presented by the claimant, the only issue which is to be determined, therefore, is whether the claimant has proved that his dismissal is a nullity as to be entitled to the reliefs he sought in this suit. The starting point in resolving this issue is to examine the reason and process by which the claimant was dismissed from service by the defendant. To do that, it is necessary to set out the content of the dismissal letter, which is Exhibit FJSC 9. The relevant content of the letter is in paragraphs 1 and 2, and they are reproduced thus. Letter of dismissal. You were alleged to have been absent from duty since 6 October 2009. Query dated 12 January 2009 was issued to you to explain why disciplinary action should not be taken. I'll see about that, about the date. I'll check the exhibit when I'm done reading to correct any other thing. Your response to the query was found unsatisfactory, and the matter was therefore thereafter forwarded to the Federal Judicial Service Commission for consideration. After due deliberation, the members of the Federal Judicial Service Commission at their meeting held on 16 June 2016 decided in accordance with Regulation 49 of the FJSC regulations to dismiss you from the Federal Judicial Service with immediate effect for serious misconduct, to wit, absence from office without permission or lawful excuse. In the dismissal letter, the reason for the claimant's dismissal is the allegation that he was absent from office without permission or lawful excuse, and the incidence of absence from office without permission or lawful excuse which resulted to his dismissal is the one for which he was given query dated 12 January 2010. I think I got the answer there. 2010. Okay. It is also clear from the dismissal letter that it was this particular alleged incidence of absence from duty for which the claimant was given a query, which he replied, that was forwarded to the defendant for consideration. It was also on this particular alleged absence from duty from 6 October 2009 up to the date of the query, the members of the defendant deliberated at their meeting held on 16 June 2016 and took the decision to dismiss the claimant from service. In the statement of defense, as well as in the evidence of DW1, the defendant narrated other incidences of absence from duty by the claimant and stated that it was the cumulative effect of these absences from duty. The claimant was dismissed by the defendant. It was averred that reports from the Lagos Division of the Court of Appeal, Lagos, in June 2010 revealed that the claimant refused to resume work. The claimant was transferred to Makurdi Division in September 2011, and he reported for duty on 22nd September 2011, but the claimant again abandoned his duty post without excuse, which led to stoppage of the claimant's salary in July 2013. A brief dated 20th April 2015 detailing the claimant's antecedents of absence from his duty post in Lagos and Makurdi was presented to the President of the Court of Appeal, and the claimant's absence from duty without permission was also reported to the defendant by the Chief Registrar of the Court of Appeal in January 2016 with a recommendation that the claimant be dismissed from service. The claimant was consequently dismissed from service on 22nd June 2016 after the members of the defendant deliberated and resolved to dismiss him for absence from office without permission or lawful excuse for about 5 years. From the averment of the defendant, the claimant had been found absent from duty without permission a number of times for a period of about 5 years, and it was these several acts and incidences of absence from duty without permission that led to the report of the Chief Registrar of the Court of Appeal in January 2016 to the defendant with a recommendation that the claimant be dismissed from service. The defendant has also told this court that the reason for the claimant's dismissal by the defendant was the several acts of absence from office without permission or lawful excuse for about 5 years. The averments and evidence of the defendant is not supported by the content of the dismissal letter. In other words, the averments and evidence of the defendant relating to the reason for the claimant's dismissal run contrary to and not in terms with what is contained in the dismissal letter. The content of the dismissal letter is clear and without any ambiguity as to the specific act of the claimant considered to amount to the misconduct of absence from office without permission or lawful excuse resulting to his dismissal. It is the allegation that the claimant was absent from duty since 6 October 2009, for which he was given the query dated 12 January 2010. The members of the defendant, as shown in the dismissal letter, did not consider any other act or incidence of absence from duty without permission with respect to the claimant in their meeting of 16 June 2016, other than the alleged absence from duty for which the claimant was queried in Exhibit FJSC2 in dismissing the claimant. Since the specific reason for the claimant's dismissal by the defendant is the alleged absence from duty from 6 October 2009 to the date of the query in Exhibit FJSC2, all other incidences of absence from duty as narrated by the defendant in this suit are irrelevant in determining the issue whether the claimant committed the misconduct of absence from duty without permission. I cannot go outside the content of the dismissal letter or consider other reasons for the claimant's dismissal which are not contained in the dismissal letter in resolving the issue whether the claimant committed the misconduct of absence from duty without permission to warrant his dismissal. I have said earlier in this judgment that the dismissal letter disclosed that the misconduct of absence from duty without permission for which the claimant was dismissed from service was the alleged absence from duty from 6 October 2009 up to the date a query was served on him on 12 January 2010. The pertinent question is to consider at this point is whether the claimant was absent from duty at the material period without permission. In his evidence, the claimant said he was transferred to the Lagos Division of the Court of Appeal in 2009, and he resumed there. In the same 2009, he participated in staff promotion exam and interview in Lagos, and he passed. While in the office on 13 January 2010, he received a query dated 12 January 2010, and he responded to the query in a letter dated 14 January 2010, wherein he denied the allegation made against him. After his response to the query, he received a warning letter dated 8 February 2010. Then in April 2010, he received a letter of notification of promotion dated 30th April 2010, promoting him to the position of Principal Executive Officer 2 Accounts on grade level 10. In 2012, he was transferred to Makurdi Division of the Court of Appeal. Then on 10 July 2018, he received the dismissal letter. The query is Exhibit FJSC2, while the claimant's reply to the query is FJSC3. The warning letter is Exhibit FJSC4. The promotion letter is Exhibit FJSC5. On the other hand, the defendant averred that the claimant was transferred to the Lagos Division and he reported there on 14th April 2009. The claimant thereafter abandoned his duty post without any reasonable excuse or permission. The claimant applied for leave on 24th August 2009, and it was granted with effect from 25th August to expire on 5th October 2009. The claimant refused to resume duty on 6th October 2009, and the Deputy Chief Registrar of the Court of Appeal Lagos Division reported the claimant's refusal to resume duty to the Court of Appeal on 7th January 2010. The claimant was issued with a query on 12 January 2010, and when the claimant got wind of the query from his colleagues in the office, he rushed back to Lagos to answer the query on 14 January 2010. The claimant was not exculpated. A warning was issued to him, and he was placed on 1-year probation to be of good conduct on 8 February 2010 because the claimant abandoned the duty from October 2009. His salary was stopped from January 2010. The claimant appealed for restoration of his salary in May 2010. From the evidence of these parties and in view of exhibits FJSC 2, 3, 4, it is not in dispute that when the claimant was transferred to Lagos, he went on leave from 25th August to expire 5th October. The claimant was issued a query dated 12 January 2010, and he answered the query on 14 January. After the claimant's reply to query was given a warning dated 8 February 2010. The fact that the claimant's salary was stopped in January 2010 as a result of absence from duty is also not in dispute. In cross-examination, the claimant confirmed that the defendant's averment, he confirmed the defendant's averment that his salary was stopped in January 2010. The area of dispute is the claimant's averment that he was not absent from duty after the expiration of his leave, as alleged by the defendant. According to the defendant, when the claimant's leave expired on 5th October 2009, the claimant refused to resume duty on 6th October, and this resulted to the query of 12 January 2010. According to the defendant, the claimant was not on duty on the date of the query, but when he was informed of the query by his colleagues in the office, he rushed back to Lagos to answer the query. The evidence adduced by the claimant to show that he was not absent from duty in the material period as alleged is that he participated in staff promotion exam and interview in Lagos in 2009, which he passed and was promoted as a result of his diligence. He also said the query was served on him while in his office on 13 January 2010, and he responded on 14th. These are what the claimant said in his bid to prove that he was not absent from duty. The claimant had referred to a staff promotion exam, an interview he participated in Lagos in 2009, and perhaps he wants me to believe that he was on duty or at work at the material period in 2009 when he participated in the said staff promotion exam and interview. The claimant did not supply The claimant did not supply particulars of the said staff promotion examination and interview and did not produce any document to back the averment that the promotion exam was in 2009. The specific date of the staff promotion exam and interview was not mentioned. The venue of the staff promotion exam and interview was also not stated. It is therefore difficult to know whether the claimant participated in the staff promotion exam and interview before taking his leave in August 2009, or during his leave, or after his leave on 5th October 2009. It is rather the defendant who provided the date in which the promotion exam, whose notification was referred to by the claimant in paragraph 10 of the statement of facts, was conducted. In paragraph 4H of the statement of defense and the evidence of DW1, it was stated that the claimant sat for the said promotion exam in March 2010, and the promotion letter was released in April 2010. In effect, the promotion exam was conducted in March 2010. The period the claimant is accused of being absent from duty without permission is the period from 6 October 2009 to 12 January 2010. The claimant has not shown that he participated in the staff promotion exam and interview within this period. Furthermore, the claimant failed to show that his participation in the said staff promotion exam and interview establishes his being on duty within the period in question. I have seen the claimant's reply to the query, which is Exhibit FJSC 3. He explained that he resumed from his leave on 7th October 2009 and was at his duty post until the first week of December, when on a verbal invitation by HOD accounts, he went to Abuja to explain some transactions that took place during his tenure as CPO headquarters. The claimant has admitted in his reply to query that he was not at his duty post in the Court of Appeal, Lagos, from the first week of December 2009. He also admitted that his absence from duty was not through official channel, as according to him, his invitation to Abuja was verbally made to him by GSM call. He has also clearly admitted that none of his superiors in the Court of Appeal, Lagos, was aware of his invitation to Abuja, and he did not seek permission from his superiors in the Court of Appeal, Lagos, to proceed to Abuja. In his reply to query, the claimant has clearly confirmed that he was absent from duty without official permission from the first week of December 2009. The claimant did not mention the date he returned back to work in Lagos after the said verbal invitation to Abuja, but he said in the last paragraph of the reply to query that, quote, "I was at my duty post when the query letter was brought to me, and I personally signed and received it," unquote. In his evidence, he said he received the query on 13 January 2010. Although the claimant is able to explain his whereabouts as at 13 January 2010, he failed, however, to explain his whereabouts between the first week of December 2009 and 13 January 2010, either in his reply to query or in this suit. Without a doubt, the claimant, by his admission in his reply to query, was absent from office from the first week of December 2009 without permission up to 13 January 2010. Because the claimant was unable to dislodge the allegation made against him in the query in the reply, that was why he was given a warning in Exhibit FJSC 4, wherein he was informed that, quote, "Your reply dated 14 January has not exculpated you from blame," unquote. By this statement in the warning letter, the claimant was informed that he was unable to satisfactorily defend the allegation in the query of 12 January 2010. In paragraph 10 of the statement of facts, the claimant averred that he was one of the diligent staff of the defendant. That was why he was promoted to the position of Principal Executive Officer 2 Accounts with effect from 1st January 2010. Then in Relief 2, the claimant sought this court to declare, among others, that it was his diligence and hard work that earned him the promotion. The defendant denied the averment of the claimant in paragraph 4 of the statement of defense and put the claimant to prove that he was diligent in his work and at his duty post at the Court of Appeal, Lagos. I have seen and read the content of the promotion letter. It is Exhibit FJSC 5. The letter did not say claimant was promoted for his diligence or hard work. The claimant had earlier pleaded in paragraph 6 of the statement of facts that he participated in a staff promotion exam and interview in 2009 and he passed. Exhibit FJSC 5 is the result of that staff promotion exam and interview. thus being promoted as a result of passing a staff promotion exam and interview is not evidence of diligence at work. The promotion is only good to show that he passed the staff promotion examination and interview, and not because he was diligent at work. Accordingly, the fact that the claimant was promoted to principal executive officer 2 accounts by the FDIC is not proof that the claimant was diligent at work or was always on his duty. In the query, the claimant was said to have been absent from duty for a period of 3 months from 6 October 2009 after the expiration of his leave. It is also a fact that as a result of this allegation, the claimant's salary was stopped in January 2010. I've also seen a number of documents tendered in evidence by the defendant containing reports of the claimant's absence from duty from 6 October 2009. Exhibit FJSC 12 is a letter dated 7 January 2010 by the DCR to the CR of the Court of Appeal, reporting that the claimant had not reported to duty since 6 October 2009. Exhibit FJSC 17 is a memo dated 19 January 2010 from the HOD admin, Court of Appeal, Lagos, to the DCR. The HOD admin reported that the claimant did not resume duty as claimed and he has not reported to the office to complete the resumption of duty certificate for onward transmission to the CR. There are also exhibits FJSC 18B and 18C, which are letters dated 21st June 2010 and 22nd June 2010 from the Lagos Division to the Chief Registrar of the Court of Appeal. It was reported that the claimant has not resumed for duty since 6 October 2009. These are documents emanating from the records of the Court of Appeal to show that there were complete complaints of the claimant being absent from duty from 6 October 2009. The reports in these documents disclose good reason to warrant the query of 12 January 2010 issued to the claimant. Having carefully considered the evidence before me, the claimant has failed to convince me that he was not absent from duty without permission in the period 6 October 2009 to 12 January 2010. Therefore, I find that there are good reasons for the defendant to believe that the claimant was absent from duty without permission from the period 6 October 2009 to 12 January 2010. It was the claimant's absence from duty without permission within the period that resulted to his dismissal from service by the defendant. Now, going by the content of the dismissal letter, it is obvious that despite the warning letter given to the claimant in February 2010, the allegation against the claimant in the query was not put to an end. The matter was further forwarded to the defendant, who is the claimant's employer, for consideration. In effect, from the time of the query, a disciplinary case was pending against the claimant, which was finally decided and communicated to the claimant via the exhibit FJSC 9, dated 22nd June 2010. The claimant has now claimed that he was never given any invitation or opportunity by anybody or the defendant to defend himself before he was dismissed from service. In Relief 1, the claimant sought a declaration that the dismissal letter is a nullity, as necessary procedure preceding dismissal was not followed. When the claimant stated that he was never given any invitation or opportunity by anybody or the defendant to defend himself before he was dismissed from service, the averment appears to be an allegation that the procedure to be followed before he can be dismissed is that he be given invitation or opportunity to defend himself. Perhaps that was why he claimed in Relief 1 that the defendant did not follow the procedure for dismissal. This became evident in the written address of learned counsel for the claimant, where it was submitted under issue 2 that the procedure for dismissal provided in Rules 46(4) of the Regulation 2010 of the defendant was not followed when the claimant was dismissed. The claimant pleaded defendant's regulation 2010 in his reply to statement of defense and tendered same in evidence. It is exhibit FJSC 8. In the statement of defense, defendant pleaded that by absenting himself from duty without permission, the claimant is not entitled to any invitation or disciplinary procedure before his dismissal under the defendant's regulation, and that the claimant is not entitled to any disciplinary proceeding before his dismissal from service. DW1 tendered a similar regulation to exhibit FJSC 8 in evidence. It is exhibit FJSC 25. In cross-examination, DW1 said exhibit FJSC 25 is a regulation that regulates the employment of staff of the defendant and that the defendant complied with exhibit FJSC 25 in issuing a dismissal letter to the claimant. He also said the claimant was dismissed under Regulation 59 of exhibit FJSC 25 and no disciplinary committee was set up in the case of the claimant. It is the duty of a claimant who claims that his dismissal is unlawful or a nullity or void to plead and prove how and what made the dismissal unlawful, null, or void. See Ante against University of Calabar 2011, Oloruntoba Uju against Abdurrahim 2009. The claimant is expected to plead and prove the terms and conditions of his appointment, the circumstances under which he can be dismissed under the condition of service, the procedure stipulated in the condition of service for dismissal, and the manner in which the dismissal breached the set terms and conditions of his appointment. Accordingly, since the claimant in this suit has sought this court to declare his dismissal to be a nullity, the claimant must satisfy the requirements of the law before he can be entitled to the declaration sought. Other than his assertion that he didn't commit the infraction for which he was dismissed, the only other allegation he made against the dismissal is that he was never given any opportunity by anybody or the defendant to defend himself before he was dismissed from service. Claimant did not plead and did not say in his evidence that it is a term of condition of service that he must be given invitation or opportunity to defend himself before he can be dismissed from service. Although the claimant pleaded the defendant's regulation 2010 and tendered it in evidence, didn't give any indication whether in his pleadings or evidence to suggest that his allegation that he was never given any invitation or opportunity to defend himself before he was dismissed from service was based on the provisions of the regulation. The claimant did not plead the procedure for dismissal in the regulation, and he did not explain how his dismissal violated the procedure. Merely saying he was never given any invitation or opportunity to defend himself before he was dismissed does not satisfy the requirement on him to plead and prove the procedure by which he can be dismissed. I will, however, not end the matter there. I think it is necessary to resolve the contention of the parties on the procedure adopted by the defendant in the dismissal of the claimant. It is not in dispute that the claimant was given a query and he answered it. From the content of the dismissal letter, it was after the claimant's answer to query that the matter was forwarded to the defendant. It is also evident from the content of the letter that the claimant was not invited or heard from by the members of the defendant in their meeting of 16 June 2016. DW1 confirmed in cross-examination that no disciplinary committee was set up in the case of the claimant. Now, while the claimant appears to contend that he is entitled to be invited to a disciplinary hearing and be given an opportunity to defend himself before he can be dismissed, the defendant clearly asserted that the claimant is not entitled to any disciplinary proceeding before he can be dismissed from service for the misconduct of absence from duty without permission. Both parties tendered separate copies of the defendant's 2010 regulation in evidence. They are exhibits FJSC 8 and FJSC 25. According to the legal counsel for the claimant, in his submission in the claimant's final written address, the procedure which ought to have been followed in the dismissal of the claimant is as provided in Regulation 46.4 of the regulation. Counsel went further to set out in extenso the provision of Regulation 44. I've mentioned earlier that the claimant did not plead the procedure for dismissal. Thus, setting out the procedure in the claimant's final written address is not of any benefit to the claimant's case. In any event, it is clear to me by reading regulations 45 and 46 that the provisions of procedure in regulation 46, 1, 3, and 4 is in respect of infractions defined to be misconduct in regulation 45, 1. Absence from duty without permission or leave is one of the infractions constituting serious misconduct listed in regulation 48.1. Therefore, the procedure in regulation 46.4 will not apply in the disciplinary action of a staff accused of absence from duty without leave. Let me also make the clarification that the opening statement of regulation 46.4 made it clear that the provision of regulation 46.4 will not apply where there are other procedures provided in the regulation for dismissal. It provides those, quote, unless the method of dismissal is otherwise provided for in these rules, an officer in the Federal Judicial Service may be dismissed by the Commission only in accordance with the regulations stated below, unquote. The implication of this provision is that where the method of dismissal is provided for in the regulation, the procedure in regulation 46.4 will not be applied. Therefore, where in the regulation procedure for dismissal is provided for specific misconducts, the procedure in regulation 46.4 will not apply. It is therefore obvious that the procedure in regulation 46.4 was not applicable to the serious misconduct of absence from duty without permission for which the claimant was dismissed. DW1 told the court that the claimant was dismissed under regulation 59. Regulation 59 provides those. Without prejudice to the power to institute disciplinary proceedings in respect from any absence from duty without leave, in respect of any absence of duty without leave or reasonable cause, where an officer is absent from duty without leave or reasonable cause, the Commission may dismiss him without following the procedure prescribed in Regulation 61 of these regulations. By this regulation, the defendant may dismiss an officer accused of absence from duty without leave by not following any disciplinary procedure. This provision is specific to the serious misconduct of absence from duty without leave, and it permits the defendant to dismiss an officer alleged to have been absent from duty without permission, without following stipulated procedure. In other words, the dismissal of an officer for the serious misconduct of absence from duty without leave can be done with or without observing any disciplinary procedure. Thus, a dismissal of an officer accused of absence from duty without following any procedure will not vitiate or nullify the dismissal. In this case, the dismissal letter shows that no procedure was followed in the dismissal of the claimant. It is evident that the defendant opted to apply Regulation 59 in the case of the claimant. Therefore, since the claimant was dismissed under this provision, the dismissal complied with the regulation. The claimant's allegation about not being given any invitation or opportunity to defend himself, which is not a mandatory requirement in the regulation in the disciplinary process for the serious misconduct of absence from duty without leave, is without merit. Looked at from another angle, the claimant's allegation that he was not given any invitation or opportunity to defend himself raises an issue of denial of fair hearing. In employment cases where an employee complains of unlawful or wrongful dismissal or termination on the basis of denial of fair hearing, the usual question to be considered in such cases is whether the procedure in the condition of service was followed or not. This is because fair hearing in employment matters does not hang in the air. The alleged breach of right to fair hearing does not exist in vacuum, but must be founded on the terms and conditions of the employment, which must be pleaded and proved. Therefore, merely alleging breach of fair hearing without showing that the breach occurred as a result of violation of the terms and conditions of the employment will not provide the saving grace. See AG against Chad Basin Development Authority 2016, CIDE against Rivers State Civil Service Commission 2007. In this case, Besides the fact that the claimant did not plead and prove that his allegation about not being given any invitation or opportunity to defend himself was a requirement of the condition of service, I also find that the defendant is not obligated in the condition of service of the defendant to invite the claimant for a disciplinary hearing and be heard before he can be dismissed for the serious misconduct of absence from duty without leave. Consequently, I find no reason to interfere with the procedure adopted in dismissing the claimant or with the claimant's dismissal. In concluding this judgment, from all my views and opinions expressed so far, the issue for determination is resolved against the claimant. I find that the claimant failed to prove all the reliefs he sought in this suit. The suit lacks merit and is accordingly dismissed. Parties shall bear their cost. Judgment is entered accordingly. All right.
Yes, Lord, we are grateful for the judgment of the court. We pray that Almighty God continue to bless the court. We are grateful.
Thank you. So, hopefully, I expect Mohammed to come get the files and get the signed judgments later today, so that we can distribute it to the council.
We thank my Lord for the well
you.
considered case. Thank you, my Lord.
Thank you. So at this point, I wish to leave the meeting room now. Have a blessed day, all of you.
Thank you.
Thank you.
The limitation.
I've not been using you let me know. So that I need to write them.
So either the fighting so able to get some order.
I want to know if anyone pulling them out and so I want to have a copy of the document, the written address.
Okay.
Put a copy in the morning and having a feeling. It was a case that's all we talk. I just saw my phone. Again, copy in won't be clear to say.
Why?
About chicken. Okay. I want to break the chair. Then once I'm at the band, the buyer. In fact, the band is star. We stamp. For me, come out. I don't know. I think there's no one of copy.
Then you know defendant okay. Naka the nas reply nas.
Meaning I reply. Reply.
Okay.
Okay. Now, one day for us and
That's the defendant final address.
yes.
With the defendant's reply. Okay.
Yeah.
Then if I reply. Which one? From commencement. Commencement.
It's a planning day in interest.
Yes, yes, yes. Yes. Honestly.
I think it's back again.
Imagine. Imagine.
She focusing on this. She wants to be in so that every weekend they can not see that.
Imagine.
One day she did play it smart. The other night you they go let me so much. So for them, I'm not the kind of like so how
Honestly. Honestly. Level 10, okay?
only get who's using sentiments.
Yes, let's go. Let's go. Let's go. Let's see how people thought about you.
No, that's the next thing.
It's okay. Not too repetitive.